Hi, I'm Adam Summer. You're listening to the Yerushalmi Talk podcast with the support of the Yeshivat Javar Yerushalayim in Har Nof, Jerusalem. This is Peah, chapter 2, Halacha 5. This is the last halacha in the chapter, and it's a long halacha. A bit about this halacha before we get started to keep some context of what's going to be happening here, because there's a lot to unpack, and I've spent the last few hours working on it because there's a lot of things going on in it. First of all, one of the things to keep in mind for one of the themes in this halacha is that it's always going to be concerned with when property is transferring to someone else. So that when property is transferring to someone else, what's going to be the status of the peah? For instance, let's say a person sells the unharvested field. Well, is the peah going to belong to the original person, or is the obligation going to belong to the new person? That's one of the themes that's going to be happening throughout this. Another theme is going to be when acquisition occurs. In other words, what is the status of acquisition for property? And that's something that's going to be coming up in the Babas, Baba Batra, Baba Kama, Baba Metzia. All these things have applications in this halacha. And then you're going to have this other case about, what happens when it's harvested itself? In other words, what's this condition of when peah starts to get triggered? And we mentioned that before, that it has to do when it starts to get harvested, but what is going to count as harvesting? So that's going to be another theme to help us to understand this, and please keep those things in mind because it's going to make it a lot easier and much more direct to understand what's happening here. So the Mishnah reads like the following. In other words, there's going to be several cases in which the landowner is going to be exempt from the obligation to set aside peah from his field, because he was not the one who actually cuts the produce. So the Mishnah reads, a field that was harvested by non-Jews, or that was harvested by bandits, or whose crop was severed by ants, or broken down by the wind or an animal, is exempt from peah. Now, when we're talking about a field that was harvested by non-Jews, the Mishnah is writing this in shorthand, and the Gemara is going to go on to explain that the Mishnah is going to refer to a field that's harvested by a non-Jew for himself, not necessarily one who cuts on behalf of a Jew. And keep in mind that a non-Jew working in the employ of a Jew is going to be considered in regard as an extension of the Jew himself. So this is one point. Another point is that it was harvested by bandits. What is the Mishnah trying to hint at here? This is talking about even Jewish bandits, and this is going to talk about what they're going to be attempting to do with the produce. What were these bandits doing? Maybe they were chased away before they completed the task, and they left the cut produce behind. And then we're going to get into ants. I guess ants can eat away the bottom of stalks of grain, and it'll leave the grain lying in the ground. Is that going to be counting as harvest? Well, clearly not. Another case will be by a wild animal. Perhaps a wild boar runs through the field and messes up the wheat field. So what happens there? So, or maybe you have a very strong eastern wind. So this is going to make it exempt from peah. Now keep in mind, one of the themes here in this halacha is always going to be this concept of when you harvest. Now go back and look at Leviticus 19:9. That's the teaching of peah in the Torah. And it's going to use the word uv katserchem. In other words, when you harvest, indicating that the peah obligation goes into effect only when you, a Jew, cuts the produce, but not when it's cut by a non-Jew. So that a field that's reaped by non-Jews is going to be exempt from peah. And by the same token, the word for when you harvest in the Torah is going to imply you. And it's going to imply that the owner of the field must do the harvesting in order for the mitzvah of peah to be in effect. So that's going to have implications on what happens when Peah in a field is going to be cut by bandits. So this is a key point to keep throughout this entire halacha, and a key point for understanding the whole concept of Peah together is the Torah says when you harvest, and that you harvest has a lot of meaning and halachic implication. The Mishnah is now going to talk about the law for a number of cases in which the owner of the field harvested part of it, and then the other part is harvested by someone else. So if the owner of the field harvested half of it, and bandits harvested the other half of it, it is exempt from Peah, even the half he harvested himself, because the Peah obligation of the harvested portion resides in the standing portion, says the Mishnah. In other words, as long as there's at least still part of the crop standing in the field, Peah for the harvested produce must be given from the standing crop and not from cut produce itself. We're going to get into that a bit later. So when someone harvests the first half of the field, the Peah is given for it is going to necessarily be displaced to the second half of the field. And then you have this incident coming along when the bandits come and do the other half of it. And so the Mishnah reads that it is all exempt from Peah, even the half he harvested himself, because the Peah of the harvested portion resides in the standing portion. So we're not being concerned with the cut portions. That's another theme in the halacha. So since this part of the field was cut down by the bandits, the owner is exempt from giving Peah even for the half of the field he cut himself beforehand. Now, the Mishnah is going to go on and teach the laws for the opposite case. If the bandits first harvested half of it, and the owner then came along and harvested the other half of it, the owner gives Peah only from that which he harvested. So that makes sense. In the case that's where it's left, what's left is standing, and that's going to be subject to Peah, and therefore, that part that's standing, that's what's going to be subject to Peah. Now, the Mishnah is going to go on to talk about obligations in another case in which the owner harvested only half the field. If he harvested half of it and then sold the other half of it, the buyer gives Peah for everything, even the seller's half. Again, we want to remember that the gifts for Peah are assigned by Hashem to the poor. So in this case, it's considered as if the original owner only sold the buyer the second half of the field minus the amount of Peah that's owed from the first half. So in that kind of case, the buyer must therefore set aside the amount of Peah needed for both parts of the field. In other words, you're not able in this situation to get yourself out of the Peah obligation. You're not. In other words, the reason for this is that the seller harvesting the first half of the field, the Peah is needed to be separated for it necessarily, and that it has to be done by the standing produce, and that's going to only remain in the second half of the field, but that obligation remains unchanged by the sale. The amount of Peah is going to be required from the first half of the field for the uncut half as well, because you sold it. You can't just sell off the gifts that are assigned from Hashem. In other words, that property and obligation is not going to transfer in this case and for what it's talking about. And that's a bit of a clarification for what's happening in the Mishnah and a way to understand. In other words, these are gifts that are signed by Hashem to the poor. You can't sell your way out of that. So the Mishnah continues, says, if he harvested half of it, and then he consecrated the other half to the temple, the one who redeems it for the temple treasurer, he gives Peah for everything. In other words, even for the half originally harvested by the consecrator. Now, one of the things to keep in mind here is that when Peah is going to be done by the temple, it's going to be exempt from Peah. And so really what's going to be happening is the amount that's left over, that's going to count as the part that's standing. So then what happens is that that part that's standing is going to be subject, and and you know, one of the things to keep in mind is sometimes property would be consecrated to the temple. In other words, be sold to the temple to raise money to help to pay for the temple's upkeep. And for this same reason, the buyer in this case, he has to really separate Peah for the entire field, namely that Peah has to be set aside for the first half of the field that's already been displaced for the second half before it was ever sold. So that the Mishnah is discussing a case where the consecrated half of the field is going to be redeemed before it's been harvested by the temple. So that's something to keep in mind. So the sugya is going to get into the first part of the Mishnah. It's going to qualify the Mishnah's first ruling that the field harvested by non-Jews is exempt from Peah. And the sugya says like this. The Gemara says like this. The Mishnah is referring to a case where non-Jews harvested it for themselves. But if they were workers who harvested it for a Jew, it is subject to the obligation of Peah. And indeed, we learn from a Brisa, one may not hire non-Jewish workers to harvest Jewish-owned fields because they are not familiar with the laws of lechet, shichicha, and peah. So this is going to imply that the obligation of peah does not indeed remain in force when non-Jews harvest the field on their own behalf. Now, look how sensitive the Torah is, that is differentiating between the Jewish workers, not Jewish workers, Jewish ownership, not Jewish ownership, so that that it wants to make sure that when you have the stalks being harvested, that too is going to be left for the poor, and the non-Jewish workers will probably gather those fallen stalks. And they're not going to be really familiar with Jewish law in order to protect the rights of the poor. And so, they're not going to really differentiate between lechet and shchicha. And from what they're gathering, they're going to be basically taking it from the poor. So I'm not sure if this law, where it says one may not hire Jewish workers to harvest Jewish-owned fields, is going to be a halacha d'oraita or d'Rabbanan. I suspect it's going to be d'Rabbanan, and this is going to be regarding, from what we know in Avodah Zarah and the Yerushalmi, this is going to be for the law in Eretz Yisrael. This is not going to be the case for the law outside of Eretz Yisrael. So there's a question of whether that is going to be d'oraita or d'Rabbanan. And I think that's going to be d'Rabbanan, but the part about it being in the land, that's going to be d'oraita because it has to. All these gifts are for grain that's in the land, but with regards to the non-Jewish workers doing it, that part is probably going to be a fence to protect the poor because we have to assume they're not familiar with it. So there's another question where if non-Jews are going to be hired by the Jew to cut it for him, then you could say, well, wait a second, this is really just an extension of the employer's hand. And we know that in other places in Jewish law. So then you could say that, well, wait a second, even a non-Jew can generally serve as doing tasks. But then you have this other issue where non-Jews are not allowed to serve as a legal agent for a Jew in regard to Torah matters. So in this case, the reason that they're able to say, no, you can't use this non-Jewish laborers, you're saying that this guy now becomes an agent of the Jew for a Torah matter because this harvesting itself becomes a Torah matter where the process, if it's not done right, you're taking away the lechet and the shchicha, and perhaps even the peah, because this guy is going to just pick it up or cut behind him. And so you're now encroaching into that area of that worker becoming a legal agent in regards to Torah matters. And we know that that's generally not allowed. So that's probably going to point to this law being d'Rabbanan. the Gemara is now going to get into the Mishnah's second ruling that a field harvested by bandits is exempt from Peah. I want to point to the concept of Yush, and we know about that in Baba Metzia, chapter 2, both in the Bavli and the Yerushalmi. And that's when the person gives up hope. And he gives up hope that the robber, ran off with the thing, and he's never going to be able to recover it. And at that point of Yush, in Baba Metzia, you really have this idea that perhaps some concept of ownership transferred. Now, the thief always owns always owes the product back to the original person. But there's going to be another concept that comes up here, that when you have a robber coming and significantly changing an object that he steals, in some way he's going to acquire the object, even though he still owes the original owner the value, not the object itself, but the value of what was stolen. So we have in Bavli, Baba Kama 96a, where a thief cuts down a tree to take it for himself, and he does not acquire it because the name does not change in the process. In other words, people will still refer to it as a tree. But in this case, we're going to see that grain is going to be a little bit different, because in Hebrew, the uncut grain is going to be kemach. The word's going to be kemach. But the grain is going to have a different word when it's actually cut, and it's going to be called katsir, so that this name change of it, being different from a tree, is going to point to this thing of, well, maybe the thief is going to go and acquire it. And another thing that's going to be important to keep in mind before we talk about this thing with the robbers is going to talk about movable product. And so depending on when it's going to be done, you can't, transferring ownership on a movable product is going to be different than an immovable product. And so if, how does the robber go and steal the land, right? So that's going to have a different set of implications than a movable product like sheaves of grain. Or another thing is that, well, it's going to count on when it's your harvest, right? So that, does the robber own the land and the standing grain? No. So there's going to be a lot of questions that are going to be coming in here, and let's get into it. The Sugya says the Mishnah is referring to a case where the bandits harvested it in order to destroy the crop, but if they harvested it not in order to destroy the crop, but rather to steal it from themselves, the crop is going to be obligated in Peah. So the Vilna Gaon points out that if they meant to steal the crop, they acquire it under the laws of theft, and if they're Jewish, their harvest is going to render it to Peah. But if they flee and they leave the cut produce behind, the original owner has to leave Peah from it. So perhaps, a watchman came and scared them off, and they ran away, and they just ran away with the grain. By the way, if you're poor and you have to be a robber, how terrible and evil it is, because you could just wait and go collect the Peah for yourself. Why do you need to go and torment this poor farmer? But anyway, one of the things that we see here is that you have two segments here. You have cutting down the crop for a destructive purpose, and that's not going to be considered a harvest at all. And in that case where it's going to be just for destruction, that itself is not a harvest, and therefore does not trigger the Peah obligation. It only has to do when the robber or the thief is going to try to acquire it and make this significant change by cutting it, and then perhaps the only time that this will get acquired is in the case where the original owner abandoned hope of retrieving this grain when he saw the bandits cutting it, and he didn't scare them away, and he gives up hope. And when you give the abandonment of hope and yush, then that's what's going to allow the robber, perhaps in this case, to acquire the stolen grain. Another way to read it is that the Gemara is going to talk about the legal responsibility occurred by a robber for the loss or damage of the stolen object, and that in itself is going to render him the owner of record for Peah. So in this way, the condition of when you harvest is going to be fulfilled by the bandit harvesting the crop, even though they own it only with respect to being responsible for what happens to it. So there's a lot going on there in this one little nugget here. So the Gemara is going to come along and reject this assertion. And it's going to think about it differently. Rabbi Hoshaya Bar Shimi said, even if you say that the Mishnah speaks of a case in which they harvested it not in order to destroy it, but to steal it for themselves, it is still exempt from Peah, because Peah is given from produce that is attached to the ground. Therefore, here's what the Mishnah is trying to say. It's trying to say that in this case, the bandit's harvest is going to subject it to the crop, it's going to subject it to Peah, and that they're going to be acquiring it while it's still attached to the ground. That's effectively what Rabbi Hoshai is going to be applying. And he continues, he says, and the land, along with whatever is attached to it, cannot be stolen. So really what he's saying is that the land is always going to be considered in the possession of the original owner, and he's really saying that at the time the Peah obligation needs to go in effect, the crop has not been acquired by the bandits, but still remain in the possession of the owner of the field, because again, it's standing and it's attached, and it's the land, and he can't steal that. So effectively, he's saying that no, it still remains in the possession of the owner, and since he did not actually harvest it, and those who harvested it did not own it, he's saying that the Peah obligation did not go into effect because of this technicality. The Gemara is, according to the Vilna Gaon, going to be saying that although the bandits do acquire the crop in the way that, it's cut and now it's movable property, what this sugya is saying by Rabbi Hoshaya is he's saying that the Peah obligation does not take effect. And the law is that if the Peah was not given on the field, it must be given from the cut produce, and that's going to apply only when the Peah is going to be subject at the time of harvest. But you can't first, a Peah obligation cannot first take effect on the produce that has already been harvested. So that, again, they just took it, they didn't harvest it, and it's this technicality on them not being able to steal something that's attached to the ground, and that it's attached to the ground. They didn't steal it. They took the grain, but the way they took it doesn't qualify for Peah, is what Rabbi Hoshai is saying. And because of that, that's why it would be exempt according to this. So the Gemara now is going to get into the case in the Mishnah in which the owner harvested half of the field, and then the robbers came and harvested the other half. So the sugya says, if he harvested half of it, and the bandits came and harvested the other half, the entire field is going to be exempt from Peah. So the Mishnah here is explaining that the reason there's no Peah requirement for the half that he harvested himself is that the Peah obligation resides in the standing portion. And that's going to be cut by the bandits. And the Gemara is going to explain the rule upon which this statement is based. By the way, according to the Vilna Gaon, this Gemara is not going to be explaining the basis of the Mishnah statement, but rather is going to be expanding on the Mishnah statement to give a general rule for how Peah is supposed to be given. And the Gemara is going to be now talking about this clause of the Mishnah, but it's going to be trying to address some of the aspects of the Gemara's last discussion. So just that's a note by the Vilna Gaon on this. And let's see what the sugya says. It says, because one can separate Peah from standing produce on behalf of standing produce, and from standing produce on behalf of harvested produce, but as long as there is still part of the crop standing on the field sufficient for Peah, one cannot separate Peah from harvested produce, either on behalf of harvested produce or behalf of standing produce. And so, if we look at the Vilna Gaon's comment here, he's basically explaining this sugya like this. He's saying that one cannot use part of the crop that he already harvested as Peah for the part that is still standing, nor can he use even nor can he use it even for other harvested produce. Peah must be given from standing produce and not from cut produce. It is from this rule that our Mishnah statement flows. For if one cannot use harvested produce as Peah, even for itself, then when one harvests half his field, the Peah to be designated for it has necessarily been shifted to the unharvested half of the field. So the Vilna Gaon is saying that some of its standing produce will have to be designated as Peah for the part already harvested. So this insight is that actually it's not necessary for the Gemara to state that one may not designate Peah from harvested produce as the Vilna Gaon on behalf of standing produce, since that is obvious. But what the Gemara is doing is the Gemara is going to be setting up an exemption for what's going to be following. In other words, this part should make sense, says the Vilna Gaon, and it's really going to be used as a tool to set up an exemption. And now let's get into what the sugya says, and keep in mind that the Vilna Gaon is saying this is an exemption. So about this exemption from the previous rule, the sugya says there are times when one separates Peah from harvested produce on behalf of standing produce. And the sugya asks, how does this occur? And it says, if he finished off harvesting his field and he left standing in it enough Peah, as soon as he harvests the first ear of grain from it, the Peah obligation reverts to the sheaves, to the harvested produce. So, in other words, this is going to move to the harvested produce, and he has to now give the full amount of Peah for this field from the sheaves of harvested produce. And the sugya is going to continue on this exemption. It's going to say, it thereby emerges that he separates Peah from his harvested produce on behalf of the standing produce. And the sugya says, and the matter does not end with his finishing off the field. In other words, the previous ruling is not going to be limited to where he harvests his entire field, except for the last 1/60th of it. So the sugya is going to move on, and it's going to say, rather, if he harvested just part of the field, and he said, quote, from here on I am separating as Peah, the sugya says, as soon as he harvests the first ear of that standing produce, the Peah obligation of the field reverts to the sheaves. In other words, it's going to move to the cut produce. So really what's going to be happening here is that that he's going to be separating the Peah from the harvested produce on behalf of the standing produce. Again, you're getting into this separation between harvested and standing, and it's trying to really drill that into our minds about this separation between harvested produce and standing produce. So the sugya continues, says, it thereby emerges that he separates Peah from the harvested produce on behalf of the standing produce, and that's going to help us to understand this whole concept. Now, I just want to go over this a little bit. So here's what the Vilna Gaon continues to say on it. He says that he now gives Peah from the harvested produce, both on behalf of that part of the crop that was already harvested, as well as a part of the crop that is still standing. Although even after cutting down one ear of grain, there is still more than 1/60th needed for Peah, The Peah designation is nevertheless nullified from the entire portion previously separated as Peah. So the Vilna Gaon continues. He says, having been designated Peah, the entire amount assumed the status of the corner of the field, which the Torah states should not be harvested by the owner of the field. Remember, the Torah itself is saying the corner of the field. So basically what that means is that if you're cutting down even 1 ear of it, it's going to violate this prohibition in the Torah not to finish off the corner of the field. So this means that the Peah designation is going to be departing from the crop, and that the Peah obligation is going to be departing from the standing field and reverting to the sheaves. So that's one way to look at it. I encourage you to go and take a look at Rabbi Kanievsky's notes on his biur, because there's a lot to say about this sugya. Again, this is going to be from an exemption, and so because this is going to be from an exemption, you're going to have a lot of things going on here. One of the points here about this, just to continue what the Vilna Gaon's going to continue, he's going to basically explain that like this. He's going to say that the 1 ear that was cut down does not lose its Peah distinction, and it continues to serve as Peah for the field. And in the case where he left exactly 1/60th of the field unharvested, we speak of an instance in which he has not yet designated the Peah. Thus, when he finally does designate Peah, he designates the entire last 60th. So both the standing grain and an ear of the harvested grain is Peah. And this ear is an example of harvested produce becoming Peah on behalf of the exempted produce. That's what the Vilna Gaon says. So the Mishnah is going to continue, and it's going to say that if one harvested half of his field and then sold the other half, the buyer gives Peah for the entire field. So the law is now going to be talking about a poor person. Remember, we had this dispute in the first Halacha where the Nasi was saying that, wait a second, you can't have poor people going and benefiting from Meiser and E and all these funny sorts of sales, because then everybody's going to go do it, and they're effectively going to be cheating for the system. In other words, let's say you're taking a sale and you're going to be saying as a poor person, okay, I'll sell you this field, but I get to keep the Peah for myself, right? So he's basically going to be benefiting from the Peah. He's going to be collecting the Peah for himself, and so he's effectively going to be getting a free 1.6% out of the deal in the transaction. And so the law is going to be talking about what happens when a poor person tries to make these sorts of transactions here. So, are they going to be prohibited to take Peah from their own field? Keep in mind that in that dispute from the first halacha, it could be that, you're allowed to do that d'oraita, but the rabbis came along for a dishonest generation and prohibited that. So that part might be offense that's made d'Rabbanan. So that might mean that there's really not a conflict, but it's just talking about an addition because the people became less honest. And we know that in other cases of law, when the people became less honest, there were offenses put in. We know that from a lot of laws in Shvius, by the way. So the sugya says like this. It says, what is the law as to whether the seller, if he is a poor person, may take and acquire the Peah that exempts his sheaves from the Peah obligation? In other words, the portion of Peah that the buyer is going to separate to discharge the obligation stemming from the seller's share of the crop. So, again, the Mara Fulda, he's going to be pointing out that the following. He's going to say, when the buyer designates Peah from the field, he discharges not only the obligation of his half, but also the obligation of the seller's half, which is now in the sheaves. And the Gemara is now going to be asking whether the prohibition against a poor person taking his own Peah pertains to a seller. Do we say that since it is the buyer who designates the Peah from his produce, it is not really considered the seller's own Peah, and he's not restricted from taking it, or perhaps, says the Mara Fulda, we say that since the Peah was designated for the sake of exempting his produce, it is still considered his own, and he's forbidden to take it. So again, it gets back to this concept of, well, you have this tithe, not tithe, but this charity part that's designated by Hashem, and when you're selling this entire portion of crop, did you actually sell that obligation? That's one way of looking at this. So a resolution is going to be proposed. Sugya says like this: let us learn the resolution from the following Mishnah. The Mishnah teaches that if one leases a field for the purpose of harvesting it, he is forbidden to take its lechet, shichacha, peah, or meiser ani. This is going to be talking about in Peah, chapter 5, Halacha 4, and the sugya is going to continue. It says, Rabbi Yudah says, when is this law so? When he leased the field from the owner for a share, such as a half or a third or a quarter of the produce. But if the owner says to him, wait a second, a third of what you harvest shall be yours, he is permitted to take the field's lechet, shichacha, and peah, though forbidden to take its meiser ani. So let's look at this ruling. So it wants to say, well, wait a second, maybe this is not exactly the same case. So what is the difference between this case and this other case in the Mishnah where you're going to say as a sharecropper, instead of selling it, that a third of what you harvest shall be yours, and the first case where the worker actually is contracting to harvest the field for a third of the produce. So in either case, the commitment to give the worker a share is going to be made while the produce is still attached to the ground. And the worker becomes an owner before the lechet, shichacha, and peah obligations take effect. So why should he be allowed to take it in the last case, right? So, in other words, he's still bound by the prohibition of being an owner. So if he's an owner, he's not allowed to take peah from his own field because it's still standing, right? So the sugya says, therefore, we must conclude that in the last case, the terms of the agreement made, quote, when you harvest a third of the produce, it shall be yours. In other words, that we have to read it like this. It means that we have to look at it where it's saying that the worker is not really granted a share in the produce while it is attached to the ground. Rather, he's granted the right to receive a share of the crop after he's harvested. Again, we have to look at it in terms of, this whole difference between when is the crop standing and when is the crop harvested. So in this case, he's only getting a share of the crop as a sharecropper after it's harvested, not before it's harvested. And so in the case of lechet, shichacha, and peah obligations, for this kind of field, it's gonna fall on the owner, not on the worker, even if the worker sharecropped it or sold it. And the worker is not going to be restricted from taking these gifts for himself after it's already harvested. But again, if you're contracting it when you're selling it and it's still standing, then you have a problem, because now you're selling something that's connected to the ground still. It's not harvested, and you still technically own it. And so you didn't actually transfer the peah obligation to the other person. You actually still have it, peah obligation. It was yours. So one way around this is going to be to sharecrop it and then take what's harvested. Okay, that's what this sugya is going to be pointing out. So now it's going to try to resolve this inquiry on what's happening with the Mishnah. And Rabbi Bun Barchia says, this ruling that when the owner says a third of what you harvest shall be yours, in other words, the worker is permitted to take peah, even though some of it is designated for his work for the share of the produce, the sugya says in effect that when a buyer designates peah for the seller's portion of a field, the seller may take and acquire the peah that exempts his harvested sheaves from the peah obligation. But that's going to be hard to understand, right? Because you're going to be saying that, well, wait a second. Even though the peah is designated for produce is going to be currently in the worker's possession, the obligation to separate the Peah never fell on him, since he received the produce only after the harvest. In other words, it was still connected to the ground, it was still attached, and he still has some sort of obligation to leave Peah. So then how can you be taking something that you still technically have, right? You're not allowed to take tithes as a cone and keep them from yourself. And that's going to be kind of similar to this. Okay, that this doesn't have Kedusha, but it's still attached to the ground. And again, it's not really yours to use in the same way, right? Because it's not yours to use because you have to separate Peah. But if you're poor, how can you take the Peah for yourself? So this resolution is going to be rejected. And Rabbi Yossi is going to come along and say like this. It's going to say, there in the Mishnah's case, we do not have a situation of the worker's field becoming obligated in Peah when it is in his possession. In other words, the worker never owned the field. And in that case of the Mishnah where the sharecropper comes along and agrees to keep part of the harvest after it's cut, he never actually owned the produce until after the harvest, and he wasn't a landowner. So in this case, the Peah obligation is going to fall entirely on the landowner because, again, the grain is going to be standing and the landowner is going to have possession of it. And that's why the worker is going to be allowed to take the Peah. But here in our Mishnah's case, the seller's half of the field already became obligated in Peah while it was still in his possession, says Rabbi Yossi. In other words, he owned the land and now he's selling it. And so now when he's harvesting the produce, he didn't get out of this obligation for the Peah. So the seller himself is still going to be subject to this obligation. And the prohibition to take the Peah is still going to be there. He's still not going to be able to do it because he didn't get out of it. So even though he sold half of the field and transferred the burden of Peah to the buyer actually satisfies the obligation that had rested on the seller. So don't forget that the reason for this is that it's still considered the seller's own Peah. He's still prohibited to take it. Now, okay, yeah, maybe the new owner has to cut it. That's fine. But he effectively didn't transfer the obligation to Peah. It's still that it's like the seller's own Peah still. Even though he's poor, it's still his own Peah. It was still his obligation to give. And so Rabbi Yossi's point is going to be that it is analogous in the case of the Mishnah, so that it's going to say like this. It's going to say, if we considered a case where one harvested half of his field and sold that which he harvested, in other words, to cut the produce, it's going to say that the buyer is permitted to take the lechet, the shchicha, and the Peah of the field, even though he's basically going to be exempt from the obligation stemming from the produce that he bought. And so he's saying that, yeah, in that case you would be correct, says Rabbi Yossi. So that is going to end this sugya. And basically, the way to look at it is going to say, like, well, wait a second. In the Mishnah's case, right, it's going to be analogous, says Rabbi Yossi, since in both the cases the person never owned the produce when it was attached to the ground. But now this other inquiry is going to come along and say that in the case where one harvested half of the field and then sold the other half, such that he owned the produce when it was still attached to the ground, he's still obligated to pay at that time. You can't infer that from the Mishnah that they cited, whether he's allowed to take the Peah designated from the portion of his crop. So the Vilna Gaon is going to say that that this Mishnah and that Mishnah is not exactly analogous, because in the Mishnah here it's talking about when the poor person actually still owned it, and in the other Mishnah it's going to be talking about when the person was a sharecropper. He never had ownership of it. He only gets ownership of the crop after he harvests it. So that after he harvests it, he gets it, but that standing grain will still be subject to lechet, peah, and shiurim. So that yeah, the poor person can go and contract to take that. But in this case, the poor person still owned the field. So he still has the Peah obligation as his own Peah obligation. Vilna Gaon says that the two cases in the Mishnah are not exactly analogous. And because of that, the inquiry is actually going to be unresolved because the example that they used is not going to be analogous. And that's a very deep insight. It helps us to understand further. And perhaps this is a puzzle that was put in there. Perhaps it's a puzzle to help us to sharpen our minds to understand, hey, wait, there's a lot going on here with this case of standing grain ownership. What happens with a sharecropper after, what happens with ownership before. And maybe that it's not accidentally put in here, like, oh, well, wait a second, these are not exactly analogous. Maybe that's put in here on purpose to leave it unresolved as a tool to teach us these distinctions, because there's a lot of them here in this sugya. So we were talking about this question about whether the seller is going to be allowed to take possession of the portion of Peah that exempts his sheaves. And the Gemara is now going to present a related question. It says, what is the law as to whether the buyer, if he is a poor person, may take and acquire the Peah that exempts the seller sheaves from the Peah obligation? In other words, now we're taking the opposite. Now the poor person, he's the buyer. What's going to happen? Is he going to be allowed to take the Peah for himself? Or is it going to be exempt? So the Gemara is going to answer. It says, this depends on the dispute between Rebbe and Rabbi Yehuda Nasi. Now keep in mind, we talked about this in the end of chapter 1, and Rebbe, who is the grandson of Rabbi Yehuda Nasi, is saying that the buyer is permitted to take the Peah for himself, and Rabbi Yehuda Nasi is saying it's forbidden to take it because of a rabbinic penalty to prevent the poor from rushing to the wine press and the threshing floors to get these special deals. Now, we could be looking at this in terms of perhaps Rebbe is saying that that this is something that would be biblically permissible, but that we're only coming along and putting on a rabbinic penalty. So one person might be talking about one aspect of the law, the other person might be talking about another aspect of the law, and they both would agree. There would be no disagreement. They're only talking about different aspects of the law. So the Mishnah says if he harvested half of it and then consecrated the other half to the temple, the one who redeems it from the temple treasury gives Peah for everything, even the half originally harvested by the consecrator. So now the sugya is going to ask a question. It says, Rabbi Pinchas inquired. He said, a harvest performed within the land of Israel on produce grown outside of the land of Israel, what is the law as to whether that produce is obligated in Peah? Now, this is going to be kind of hard to understand. We have, land-dependent mitzvahs like Peah that are going to apply only to Eretz Yisrael. And so perhaps you're talking about a boat that had earth with ready-to-harvest produce growing on it, and it's arriving from overseas to Eretz Yisrael, and the produce is going to be harvested in Eretz Yisrael or the waters of Eretz Yisrael, or perhaps some produce grew to maturity in an area bordering Eretz Yisrael, and then the area was then conquered and annexed by Eretz Yisrael. And so then what would have been the status of that produce after it was harvested? So this doesn't seem as strange as it looks. These are two ways to explain what just happened in this case. In other words, what Rabbi Pinchas is saying. Let me read that again, because again, it seems a little strange. A harvest performed within the land of Israel on produce grown outside of the land. What is the law as to whether that produce is obligated in Peah? And the sugya says, now do not be quick to conclude and say that it is exempt from Peah, since it grew outside of the land of Israel, because it is possible to argue as follows, says the sugya. Hekdesh is exempt from Peah, and likewise, produce grown outside of the land is exempt from Peah. Perhaps, therefore, says the sugya, just as hekdesh would be redeemed before it was harvested, so that at the time of its harvest it belongs to a common person, and that's going to make it obligated in Peah. And so too, produce grown outside of the land, but was harvested within the land, is going to be obligated in Peah as well. So in other words, it's saying like this. It's saying that perhaps we should learn from hekdesh that what is important is not the point at which the produce grew, but rather the point at which it was harvested. And we know that, well, wait a second, we were just learning that before with what happens if it was a third ripe, what happens if it was before a third ripe, what happens if it was after a third ripe. So really what he's pointing out is, well maybe this is talking about, we shouldn't look at where it's growing, but maybe the key point of when something's going to become obligated is going to be the point of harvesting, not necessarily where it grew. So the Gemara is going to resolve this inquiry. It's going to say, it was found in a brisa that says like this. It says, and when you harvest the harvest of your land. It's going to quote again from Leviticus 19:9. It's going to say, this implies, but not a harvest of outside the land. It's going to be basically saying that the term harvest in the expression of the verse in the Torah is going to say that, and when you harvest the harvest of your land, is going to be referring not to the act of harvesting, but rather to the crop that was harvested. Therefore, the verse is going to apply only that a crop which grew in Eretz Yisrael. In other words, it has to be a crop of your land. That's going to be obligated in Peah. So that is the way the Gemara is going to resolve this question. Very good question. The Mishnah now is going to go to the last part of it, and it's going to say like this. It's going to state that if a farmer is harvesting half of the field and he consecrates the second half, and subsequently somebody redeems the second half, when the redeemer harvests what he redeemed, he has to leave Peah for the entire field, both the portion he harvests now and also the portion that is harvested by the consecrator. So the Gemara is going to discuss a variation of the case. Now keep in mind, when he designates it to the consecrator, that the portion in his half is still standing. So the Peah obligation is still his, and that's what we're talking about here. So the Sugya says, it's going to talk about a variation of this case. It's going to say, if the temple treasurer harvested half of the consecrated half, but he did not manage to harvest the remainder before somebody redeemed all of it, the law is that the redeemer separates Peah from the portion ultimately harvested by him for the portion harvested by the consecrator. But whatever was harvested in the possession of hekdesh is already going to be exempt. So, in other words, after the temple treasurer harvests half of the consecrated half, someone comes and redeems the consecrated half of the field, and they proceed to harvest the unharvested portion. So this is going to be opposed to the Mishnah's case, in which the temple did not harvest any part of the field. Rather, the consecrated half is going to be redeemed entirely in its unharvested state, and that's going to be harvested in its entirety by the redeemer. So keep in mind that the harvest of hekdesh is going to be exempt from Peah. And there's a lot of approaches here. Let's take a look at the meaning of the Gemara from the Mara Fulda. It says, in the Mishnah's case, in which hekdesh did not harvest any part of the field, the Mishnah ruled that a person who redeems the unharvested portion leaves Peah from that portion of the entire field. Because again, his portion that's unconsecrated is still standing. So he still owes it because he's got the standing crops in his land that's still standing there. He still has it. But this is going to be a little different. The Mara Fulda explains, by contrast, in this new case, in which the hekdesh harvested part of the field separates Peah amounts, must be left from the crop harvested before the consecration and the crop that will be harvested afterwards. And this is because the harvest of hekdesh, which is already exempt from Peah, intervenes between the two Peah obligated harvests, and requires that they have to be dealt with separately. So anyway, this is the end of chapter 2, and now we're going to get into chapter 3, and it's going to talk about what happens when you're having grain fields that are going to be next to tree fields. So we're going to continue tomorrow. Chapter 3 tomorrow.